With the session being seated.
Okay, thank you. We're back. The panel is now consisting of, we've added Justice Margaret Grant to our panel here. And once I find the docket of this, I will call the case. Give me a second. Oh, thank you very much. It's 22P556, Trustees of Wendy and John Lee Family Wealth Trust versus Trustee of Johnny Court Realty Trust. And we're hearing from Mr. Goldberg, I take it, for the appellants.
Yes, Your Honor, and may it please the Court. My name is Lane Goldberg, and I represent the appellant, Tao Kai. The trial court's ruling should be reversed, and the Boston Zoning Board of Appeals decision should be affirmed. The requirements under the applicable Boston Zoning Code article, which is Article 32, are met. Mr. Kai's project, as it was submitted, only requires an adequate stormwater infiltration system, a system to help capture stormwater and promote the restoration of groundwater within the area.
It's your position that Article 6 doesn't apply at all?
Exactly, yes. And Article 6 does not apply because the use of the property is staying the same. It's a residential use, and that use is not changing.
So could your client build an enormous waterfall, Niagara Falls, on his property, and as long as it complied with the groundwater, Article 32, it wouldn't matter if it created a nuisance or a danger?
So the waterfall would not be the same. It wouldn't be the same use. So the use is what drives the conditional use permit in Article 6. So Article 6 is for conditional use permits. And a conditional use permit is, it's a permit that's, it's for those uses that are not allowed as of right, nor are they forbidden. So examples of uses are, in this case, a residential use, industrial use, restaurant, takeout restaurant. There are many different uses where my client is continuing that same residential use.
So it doesn't matter whether it goes from a two-family residential, and I'm hypotheticalizing here.
Yes.
From a two-family to a 20-family. Doesn't matter.
To a 20-family, it may. In order to determine that.
This was 2 to 5.
Yes, so in order to determine that, you would look at the use tables in Article 43. So Boston is divided into many different districts, and this property is situated in the residential Chinatown district, and that's pursuant to Article 43. Within Article 43, much like all of the other districts, it has its own use regulations and its own dimensional regulations. So here, if you look at the tables, and it's in the addendum to the brief on page 191, the height is within the regulation for Article 43. So going up 2 stories does not create any violation for the height. Also, you have to look at the use tables. So it's, you have to look through the entire code to make sure that you're not in violation. So if you look at the use tables, and that's in the addendum to the brief on page 221, this continued residential use is allowed as of right. And when I say as of right, that means that it's not a conditional use, it's not a forbidden use. So in those use tables in Article 43, it's columns, and you'll see columns of, restaurant use, and then you'll see either an A, a C, or an F beside that specific use. If you look at Article 43, in the column for residential use, you'll see an A, which is allowed. And so that's why Mr. Kai's project, as it was submitted, it's only pursuant to Article 32. And what Article 32 requires is that stormwater infiltration system.
So on the board's decision, and I'm looking at Record Appendix page 477, it says the Board of Appeal finds that all the following conditions are met. And then it goes on to list the 5 conditions from Section 6.3.
Yes.
So if Section 3 doesn't apply, why are they making findings under Section 3, under Section 6?
Yes, and I would submit that the board, in just listing those conditions, is stating that it doesn't create a nuisance because the use isn't changing. The parking isn't going to be, the vehicles aren't going to be it's not going to change anything. So by just listing those uses, or those conditions from Article 6, it's merely stating that it meets Article 6, because in Article 32, there is reference to Article 6.
Can I ask, what happened before the board? I think, I kind of recall seeing something in the record. It was a very, very abbreviated hearing. It was none of this, the expert, Professor Lambrecht, I take it he didn't appear before the board?
No. Generally, and this is in the record, there's no testimony before the board on what's called a GCOD-only appeal. Here it's, and GCOD is Groundwater Conservation Overlay District, and that's pursuant to Article 32.
Right.
So Article 32 is GCOD. And this was, it's
The
called
letter that says that it meets the requirement of GCOD by the water board, right?
Yes, so the Boston Water and Sewer Commission, generally on a GCOD-only appeal, provides a letter that certifies that the conditions that are required by, or the requirements under Article 32 have been met. So there's two requirements there. First, that the proposed project is required to promote infiltration of rainwater into the ground in that stormwater system. And then the second requirement is that the proposed project will have no negative impact on groundwater levels. And the Boston Water and Sewer Commission, in providing that letter, looks at the engineering plan, the civil engineer's plan, and that's in the record appendix as well. So if we just limited it to the GCOD part, Justice Sanders finds that there's a possibility of flooding. Like, is she going? That's even as limited to Article 32, isn't it? No. So there's no requirement for looking at the effects of abutters with this, and within Article 32. That would be, and there was testimony by Mr. Ludlow, by our expert, Mr. Patch. In Article 32, there are no provisions that state that you need to look at the effects of your renovations, your construction, anything like that.
Actually, Section Article 32 wants flooding, right? They want lots of water going back in.
They do. They want the rainwater. So instead of it running off into the sewer system and being pushed away from the property, they want that rainwater into that stormwater infiltration system.
Okay, I just want to know, so what happened? So the hearing on this GCOD only is a very abbreviated thing. Nobody came in to object, or to say that there are other factors you should be considering. Is that true?
Generally, no, and those are scheduled first on the list at the ZBA, because they are so summarily decided on when there's no other issue. So, for example,
this particular one, nobody did, where there was any opposition?
There was none on the record.
It was a letter.
I'm sorry?
Wasn't there a letter?
Oh, I apologize. Yes, I just misspoke. So in the decision, it did reference the letters of opposition. I didn't ever see those until the trial on this. So they weren't ever sent to my office, or I did not receive any of that opposition that was before the ZBA. So yes, you're right, Justice Grant. There were letters of opposition, and the board did state that it read those letters and still decided that the project should be allowed.
So the experts at the trial, even your expert, sort of agreed that there might be problems at some point, but this isn't the time to talk about it. I'm paraphrasing, but when is the time to talk about it?
Yes, and you're absolutely correct. The time to talk about it is the BISD, the Boston Inspectional Services Department. Once this is approved, and this is in the architect, testified that this is really to see if the project is from a viable legal perspective, whether the zoning can be allowed here. Then once that's approved, then there's a development phase, a design phase and a construction phase. And Mr. Patch had testified to all of those phases, and that's when the soils are tested. There are different ways that can be allowed to construct this property in a proper way. And Mr. Patch testified that if along the way you find that you can't build this because it's going to affect the abutter, an engineer can't sign off on this, and Boston will not sign off on this. So this was just the preliminary phase here before the ZBA to see whether this can be allowed in terms of whether that stormwater system is sufficient to hold what Article 32, that narrow focus of Article 32, is going to, it is requiring here.
And do you have any authority that says that Justice Sanders or the court couldn't go beyond that?
Yes.
That's kind of what you're suggesting, that she exceeded the authority that was before her for that case, correct?
Yes. So in her opinion, and this is what the Lees are arguing, is that the use is, it's a different definition that they use. They're stating that it's the nature of the project, and they stated that it's what Mr. Kai intends to build, and it's the construction and the dimensions and the development that comes into the definition of use. And if you read Judge Sanders' opinion, it goes from that definition into the effects of the abutter's property. That's not the correct definition of use. Use is, it refers to how a particular property will operate once it's constructed. So again, that residential use, takeout use for a restaurant, industrial use. So in using that definition, and there's no citations to authority for using the word use as that definition. In using that, the trial court focused on those other problems that you had just mentioned. So that could, potentially affect the leased property. That was rainstorm causing flooding, alleged structural damage, things like that. And I assume that the Lees will devote a majority of their time talking about those possibility of impacts to the property. But the key here is, in the focus here, is that Article 6, neither Article 6 nor the actual pertinent code section here, Article 32, requires or even suggests that the board evaluate a proposed project's impacts on abutters where the project's use is not changing, and then also the dimensional requirements are allowed as of right. So going up 2 stories, that's allowed as of right under the zoning tables in Article 43, and the use is allowed as of right. So looking at...
Sorry. I'll call it the trial, it was really a hearing, but at the hearing stage, was any of this objected to, that it was going beyond the scope of what was before the court?
Before the board or the trial court?
Before the trial court.
Before the trial court. Was any of the
Well, like
evidence...
you just said, the Lees just are going to argue, as they did in their brief, that talks about how it affects the abutters, et cetera. You're saying that that was beyond the scope of the court's authority. They shouldn't have even really looked at that. Was any of that evidence objected to at the trial or the hearing?
To my knowledge, the evidence was not, because they had raised the issue, and so that was not objected to, but there was a brief, and the Lees had said that this Article 6 issue did not come up. They filed a surreply on this. That's not, that argument is without merit. The proposed rulings of law were submitted, and it cited to the KCI case, which is a very similar case here. And at the trial, the attorney for the appellee, for the Lees, had asked to brief the Article 6 issue. It wasn't briefed at that time, but post-trial, there were briefs on the Article 6 issue stating that this is not something that a court considers. So that was before Judge Sanders, before she made a ruling on this case. So just real quickly, I do want to state that the KCI case is very relevant here. It's a similar case because it happened in Boston. There, the court had stated that that Article 6, those A through E factors of Article 6-3 A through E don't apply because the use is allowed as of right. And the only reason that that the court decided that G of Article 6-3G applied is because G specifically referenced that specific overlay district, which was Article 29. I see my time is running out. I just want to get to the one issue that the judge had mentioned in passing in the argument, or in her decision, The board didn't delegate its authority here, and this goes to your questioning here. When does this all happen? Those issues are not supposed to be before the ZBA. The ZBA is not able, and that's why there's a technical review here. So the third requirement under Article 32 is that the Boston Water and Sewer Department provide that technical letter stating that the requirements are met under Article 32. The other issues here, the supposed issues with the abutters property is not to be reviewed by the ZBA. They're just not capable of reviewing that, and that would mean that really no property would able to be approved through the ZBA, because there's always going to be supposed issues. That's what the BISD is there for, to check those.
If we were to reverse Judge Sanders, what would be the remedy for the Lees to bring up these substantial concerns? And if we were to reverse on this very technical legal basis,
Yes.
what would be their avenue for raising those same concerns to prevent a building that might actually cause a collapse of the foundation or something like that?
The remedy is to, one, trust in the process that the BISD is there to, for every step along the way, an engineer needs to get sign-offs on how to construct this. And Mr. Patch had testified that there are things that you put on the building to make sure that it's not, when you're blasting or doing things, that it's not shaking the building too much, it's not affecting the building.
Can a citizen ask, or a butter ask BISD to make particular inquiries, or they can ask the building inspector to find something out of compliance?
I would assume that they would be able to be notified of anything that's going on with the building that's next door. So, and I see that I'm out of my time, but that would be their remedy, is to notify the BISD that I am a direct abutter and I need to know every time that you're coming out. And I don't think that that would be an issue with a public entity such as the BISD. But before the ZBA, that issue is not before the ZBA. Thank you.
Thank you. Good afternoon.
Good afternoon, Your Honors. My name is Bethany Lee. I represent Wendy and John Lee, the 7 Johnny Court immigrant homeowners. 7 Johnny Court, as you know, is a row house that is adjacent and shares a party wall with 9 Johnny Court. And Chinatown is well known to many as home to generations of immigrants like the Lees. What is less well known is this particular issue today, that there are public safety concerns with the foundation underneath Chinatown. These hazards are precisely what the GCOD is supposed to address, and it's precisely what the ZBA is tasked with addressing as a result of the zoning code. Prior to the GCOD, demolitions of buildings were happening in downtown Boston because the land that's filled in with muck and trash and sand underneath this area couldn't hold the weight of the buildings. And so at its most basic, this case is actually about plain text analysis. The safety concerns that Justice D'Angelo referred to in the record, and the ones that I just mentioned here today, are exactly what the plain text of the zoning code requires projects like 9 Johnny Court to address, so that by obtaining a conditional use permit and showing that there aren't going to be dangers to the neighborhood as a result of the project.
Counsel, what specifically part of the building code, of the zoning code, allows the judge to consider the structural stability? Can you point to the specific provision?
Yes, Your Honor. So Article 32, I'm going to point you to Article 32, and this is perfect because we're talking about the plain text here. It's Appendix 457. Article 35 first states, and I quote, "Any of the improvements specified in sections 32(4)A to C shall require a conditional use permit." It's not disputed here that this project is covered by Section 32(4)A to C. Section 32(6) of the GCOD then says that in order to obtain a conditional use permit, it has to adhere to the standards of Article 6. Article 6 runs through a variety of safety criteria, including a showing of no adverse impact and no nuisance. It's precisely these types of safety concerns that the GCOD is trying to address. Now, counsel just now went kind of in depth a little bit about the word use. And I want to clarify that because there's an important difference between uses that impact safety concerns and uses that don't impact safety concerns. The G-Cod is concerned with the uses that impact safety concerns, and you can see that when Section 32.4A to C is focused on additional dimensional and structural load that's being added to properties or to developments. And so it's these very safety concerns on filled-in land in downtown Boston that are driving the text of the G-Cod, which requires, among other things, a conditional use permit application in order to build certain types of buildings. And it certainly doesn't cover, this is not the same as SCIT. Opposing counsel tries to frame this G-Cod as outside of the authority of the Zoning Board of Appeals and to frame that Judge Sanders exceeded her authority. That is actually not the case. The G-Cod is very explicit in its safety concerns and the additional bulk and load that's being added to the building. And it doesn't cover, as in SCIT, all uses in a district. It's actually concerned with a particular subsect of uses. It's, again, like I said, 9 Johnny Court is covered because it's covered by Section 32.4A to C. And if you look at that section, one of the subsections that's not covered is subsection D. It's important to note because that's about paving and surfacing. That's not the type of project or new use that will add to the load of a foundation. And in this particular case, you'll see that Justice Sanders was actually incredibly concerned. The record shows that was concerned with the real risk. That's to quote the opinion, the real risk of the structural integrity of these buildings. Because what the trial court found is that the settlement, which is the movement down a foundation, which is a characteristic of filled-in land, is already happening on Johnny Court. It's happening.
Opposing counsel is suggesting that that's what the BISD procedure is for, that that's where structural issues would come into play. What do you say about that argument? It's
simply not true. I mean, so the zoning code requires the Zoning Board of Appeal to consider the adverse impact, the nuisance, whether or not there's going to be potential negative impact on the neighborhood. Certainly when we talk about structural integrity in an area, in a G-Cod district that is concerned specifically with filled-in land that creates unstable foundations and has previously resulted in demolished buildings because of unstable land, certainly this is where this is what the Zoning Board of Appeals should be concerned with because it's required by the zoning code in the G-Cod, Article 32, to be concerned with this. In fact, the Zoning Board of Appeals is specially tasked to be concerned with the G-Cod's unique risks and of structural integrity on filled-in land. That's what the Boston City Council decided to do when it implemented the G-Cod in the zoning code. And if I could take just a moment to talk about the purpose and the origins of the G-Cod. It's neighborhoods that are affected by filled-in land that include the majority of downtown Boston that the G-Cod covers. And the City of Boston implemented these safety concerns in direct response to the structural integrity hazards that it had seen with buildings.
I want to ask you, who do you say, what entity messed up by not considering these factors? Was it the Water and Sewer Commission doing the G-Cod review? Was it the Zoning Board of Appeals? Who was supposed to consider, structural integrity?
The Zoning Board of Appeals was supposed to consider structural integrity because it's required by Articles 32, and as a result of the 32.4A to C, Article 6 to consider the structural integrity and all the potential adverse impacts that are required and nuisances required by Article 6.
So is an applicant required to submit, say, engineering studies in that when they're seeking a project like this?
It's case-specific, Your Honor. In this particular case, what the trial court found is that because of the unique risks associated with 7 and 9 Johnny Court, the fact that there's already settlement that is occurring at 7 and 9 Johnny Court, it's because of those risks that in this particular case, Judge Sanders required the soil pit, the test pits that would look a little bit more into what the soil and the foundations are. And in this particular case, and that would actually not be not very taxing on anyone doing one of these projects. It takes just a few days and is a few $1,000s. Yes.
The judge in Perry said that digging test pits would be an exercise in futility because water flows downhill, essentially. Why wouldn't it be an exercise of futility here?
And so if you look at the testimony that our expert, Professor Lambrecht, submitted, it actually is important for doing borings or test pits to understand what exactly it is that the foundation consists of. In this particular case right now, despite the fact that it's in a GCOD district, no one knows what the foundation actually consists of. People don't, no one knows, the developer certainly doesn't know whether the project is going to be building either on completely filled-in land, which is actually even more dangerous, or wood piles, which still causes the possibility, which is what creates the possibility of settlement in the first place. I would also...
Counsel
yes.
suggests that, I don't want to say performa, but these petitions in front of the zoning board are just letters and they make a decision based on letters. Are you suggesting that there should be a full hearing with the butters having a right to be heard before the zoning board?
Yeah, it really depends on the project itself. And so at the very least, what the Zoning Board of Appeals should be doing is following the plain text of the GCOD, which is concerned in this particular case with the potential adverse impacts. And when we talk about this GCOD district, we're talking about the instability of filled-in land. I mean, the Zoning Board of Appeals certainly allows the possibility of opposition. And in this case, you asked about opposition letters. If you look at Appendix RA2, 5, there are a number of petitions submitted by many people actually in this court today who were opposed to not just the original iteration of the project, but also this current iteration because of the structural impact on 7 Johnny Court. I mean, it's important to note that these are not just kind of normal single-family houses. 7 Johnny Court is actually, they share what's called a party wall. So the wall is the same, and what that means is that the settlement that is occurring actually goes to, because of the way, I learned a lot about engineering in this trial, because of the way the wall joists run, the weight of added load, and here we're talking about nearly double added load on 9 Johnny Court. The weight of that goes to the party wall, so that will directly impact 7 Johnny Court when we talk about its structural integrity, especially because the evidence of settlement is already clear.
And the zoning board, if I read the record correctly, didn't look at all about the impact on the party wall. Is that
That's correct, Your Honor. The zoning board didn't, I mean, at least, well, one of the issues is we don't know what the zoning board looked at. But what we know, and I think this is actually very important, is that the zoning board did apply and interpret the zoning code to apply Articles 32 and Article 6, as you were noting. And that's important in this case because the zoning board is entitled deference in terms of its interpretation of the zoning code. What the developer is asking this court to do today is to not only ignore the plain text of the zoning code in Articles 32 and Article 6, but it's also asking your honors to ignore the deference that's owed to the zoning board in interpreting the zoning code. Your honor should not do that here today. You should adhere to the plain text, give deference to the zoning board's interpretation of the zoning code, and affirm the lower court's decision.
What about the fact that the zoning board took a view and Judge Sanders heard testimony? To whom do we defer about fact-finding?
So it's kind of a hybrid standard, which maybe we are used to in this post-pandemic world. And what happens is that the trial court actually reviews the facts de novo. And so, which is what she did in the 3-day trial, but the interpretation of the zoning code is given deference.
So I asked Attorney Goldberg, what would happen if we reversed, if we affirm, I'm looking at the order. The order is judgment in favor of your client. What does the developer, what was the judgment? What did the judge say is going to happen now?
The developer could do exactly what the judge said, which is go and do a few test pits, again, a few $1,000s, a few days of work, and then it can get its conditional use permit.
They have to, so they have to reapply to the ZBA?
Yes, Your Honor. The judge annulled the decision. I know that I'm running a little bit out of time. I want to actually address SCIT and this idea that Judge Sanders exceeded her legal authority, because that's simply not true. It's an inaccurate statement. It's also, I would say, this particular argument was forfeited by the developer. It was not raised at the trial court. While the developer said that Article 6 didn't apply, what he said was that the use wasn't changing. And now, for the first time in appeal, the developer is arguing under SCIT that the provision of the G-Cod that makes Article 6 applicable should be entirely invalidated. That's just wrong, first of all. Well, it's forfeited, first of all, and then second of all, it's wrong, because in SCIT, whereas all of the uses in that district were covered by a bylaw that required special permits, that's not happening here. What's happening here is that there's a targeted way of addressing safety concerns through the conditional use permit that the G-Cod requires. And so just to note that Judge Sanders was not beyond her authority in applying both Articles 32 and Article 6, nor was the board beyond its authority in applying both articles.
Attorney Goldberg was trying to explain to us how the tables work for determining what uses are allowed in particular districts. Do you disagree that the use that the developer wants to make is allowed in this zone?
Yes, Your Honor. This is actually exactly why I addressed in the very beginning that the use of the word use is not.
So in the way they define use, you agree that they're right. You put a different.
Yes, there's an important difference, as I said, between uses that impact safety concerns, which is what the G-Cod is concerned with, and uses that don't. And so I would ask that Your Honors adhere to the plain text of the zoning code, to give deference to the board's interpretation of the zoning code, and affirm the decision below.
Okay, thank you very much. Very interesting case, very tough case.
Very helpful.
Thank you, Your Honors.
Very helpful.
Thank you.
It's submitted, and that concludes our session for today. I want to thank the court officer and the clerk.